Okay, here's a rundown of the Scottie Scheffler arrest this morning. I'll walk you through all 4 charges and tell you what's going to happen. Basically, this is one of the 4 golf majors of the year, huge event, $17 million purse, 4-day event, and on day 2 we wake up and the world's #1 golfer has been arrested and booked on 4 charges while he was driving to the golf course. What the hell happened? Well, there was an injury causing death in a separate accident that backed up the highway. They have 2 routes of traffic, one for general public, one for golf course traffic. He's trying to go towards the golf course traffic. Officer tells him to go towards the other direction. He's like, no, you don't understand. I have to warm up and tee off. Officer says, nope, you got to go this way. Scheffler apparently disobeys, drives towards the golf course traffic. Officer tries to stop the car, grabs on the car. 10 yards later, Scheffler stops the car. Officer falls to the ground, scrapes and bruises, gets Scheffler out of the car, books him on 4 charges, takes him downtown. Quickly processed and released. He makes his 10 a.m. tee time. Wild scene. It's all over ESPN. So what's going to happen? Well, first thing before we get to the charges, you have to understand that almost every criminal charge has an intent element. It's very important what Scheffler intended to do or what knowledge he had of certain facts at the time. So, for example, one exception would be speeding. It doesn't matter if you were intending to speed. If you're over the limit, that's a speeding charge. Or statutory rape. It doesn't matter if you didn't know she was under the age, you're still guilty. Almost every other charge is going to have an intent element, including these ones, and that's what Scheffler is going to argue to get out of them. So let's go through the 4 charges. Number 1, assault in the 2nd degree. In Kentucky, a person is guilty of 2nd-degree assault when he intentionally causes a serious physical injury to another person. Okay. First of all, he didn't intend to cause the injury. He probably didn't even know it was a police officer. He maybe thought it was a unstaffed or officer or just third-party security personnel. He also going to say he didn't know that he was receiving directions from the officer. So that's going to be hard to pick the intent element, especially because there was no serious injury. Number 2, a person can also be guilty of 2nd-degree assault if he intentionally causes physical injury, not serious, just physical injury, to another person by means of deadly weapon or dangerous instrument. A car would fit that description, but was it intentional? Hard to say. And then the 3rd option is the person wantonly, basically recklessly causes serious bodily injury to a person by means of a deadly instrument. So yes, a car would count there. Yes, it was maybe reckless what Scheffler did, but there was no serious injury. So I don't see the assault charge sticking, which is very important because 2nd-degree assault is a felony, 3rd degree, or any other downgrade would not be. And that's important for Scheffler. I think he'll get out of that charge. Number 2, criminal mischief. A person is guilty of criminal mischief in the 3rd degree when he, having no right to do so or any reasonable ground to believe that he has such right. Okay, stop right there. Did he knowingly endanger that officer? Did he know that that officer was grabbing onto the car? This one might be a difficult one to stick to. I'm not confident in that one. Okay, charge number 3, reckless driving. This one might stick in Kentucky. The operator of any vehicle upon a highway shall operate the vehicle in a careful manner with regard to the safety and convenience of pedestrians and other vehicles upon the highway. Maybe, maybe not. Might be able to get this one to stick. Might be able to downgrade it to a lower charge. I'm not even going to push on that one. If I'm Scheffler, fine, I'll pay my fee as long as I get that felony assault reduced. It really isn't going to be an issue. And then number 4, complying with the traffic officer's signal. No operator of a vehicle, after having received a visual or audible signal from an officer directing traffic, shall knowingly or wantonly disregard the signal so as to interfere with or endanger the operation of traffic officer or other vehicles or pedestrians. Maybe this one sticks too, but you're really not worried about it. This is a typical citation. Again, having received a visual or audible signal from an officer, Scheffler is going to argue that he didn't know he was getting directed in one direction or another, and he's going to argue that he didn't know it was an officer. He thought it was just, course security personnel. So look, this is all going to go away pretty quietly. I think definitely the assault charge is going to be reduced to a charge lower than a felony. The mischief, I don't think is going to stick. Reckless driving and disregarding a signal, maybe, but at that point, that's peanuts to Scheffler. It's really not a big deal. So this is all going to go away quickly. Enjoy your golf weekend, and thank you for enjoying the fine print of the Kentucky Penal Code with me this Friday. Have a good one.